Good afternoon. My name is Norman White, and I am the hate crime victim advocate at the Chicago Commission on Human Relations. Welcome and thank you for joining us. It is my privilege to be moderating today's webinar, an overview of the housing ordinance and how to identify and report housing discrimination to the Chicago Commission on Human Relations. As a reminder, we wish to state the following disclaimer. Today's program is for general information purposes only, and it's not intended to constitute legal advice. The Commission on Human Relations is a neutral party on any and all matters before the Commission. Viewers should contact their attorney or legal services provider to obtain advice with respect to any particular legal matter. The use of and access to the webinar does not create an attorney-client relationship between the viewer and the commission. The goal of this webinar is to educate the public to know your rights when looking for housing in the city of Chicago. If after watching this program you believe you may have been a victim of housing discrimination, please contact us. We are here to assist. Now, please use the chat feature to submit any general questions you may have. There will be an open question and answer session after our panelists conclude their presentation. We really want to hear from you. Now, I'd like to introduce Nancy Andrade, Commissioner of the Commission on Human Relations, who will provide opening remarks.
Thank you, Norman. Hello, I am delighted to welcome you to today's webinar. Thank you for taking the time to join us and learn about your housing rights. April is Fair Housing Month, and to create awareness of one's housing rights, we are presenting this program to empower you. This is the first of a series of webinars the Commission will be presenting. Future topics will include workers' rights and employment discrimination. If you would like to suggest a topic for the Commission to cover, please email us. We welcome your thoughts. If you have any friends or family who were unable to attend this program, please know that it is being recorded and will be accessible to view at any time on our website. We are creating a virtual library for the public to learn about the rights one has under the Chicago Human Rights Ordinance, as well as the Fair Housing Ordinance. The work of the Commission is to investigate and review complaints of discrimination in housing, employment, public accommodations, credit, and bonding based on 16 protected classes. You will learn about these classes in more detail later in this presentation from my colleague, Joanne Newsom. Please use us as a resource. We are here to help. If you are not fluent in English, we have Spanish speakers who can help. And for all other languages, we have access to a language line phone service that will provide translation services. If you have physical limitations or are deaf, hearing impaired, or blind, or visually impaired, we can provide accommodations so you may file a complaint. The pandemic has changed the world we live in, and we have learned to adapt as we continue with our day-to-day routine, including the search for housing. But when searching for housing, let me remind you that you are entitled to do so in a dignified and respectful manner. Housing is fundamental. It's a fundamental human need, and we are here to assist you in the event you believe you have been a victim of discrimination. And now I would like to introduce Marissa Nevada, Commissioner of the Chicago Department of Housing, who will give an overview of the services and resources of the department. Commissioner?
Thank you, Commissioner Andrade. I am really happy to be here. I appreciate this forum. As you can imagine, at the Department of Housing, housing is what we think about all the time. And for me personally, my first work in the housing field was in tenants' rights. And from there, I went on to work in housing development and so on. But my roots in this work are really in the rights of tenants in the housing space. And so I'm very glad to be part of this webinar. I'd like to tell you a little bit about our department and how our work intersects with the work of the Commission. So the mission of the Department of Housing is to expand access and choice for residents and to protect their right to quality homes that are affordable, safe, and healthy. And we do that in several ways. We create affordable rental and for sale housing. We pay for it with our resources and federal resources. We assist residents to stay in their homes through things like roof, porch, and heat repair. And we do accessible, we do things to allow seniors to age in place by adding things like grab bars and things of that nature within homes. And then we also monitor the properties we've invested in and ensure that they continue to be quality, safe places to live. Also, just one thing, because sometimes this is confusing for folks, so I just want to note, we are separate from, but we work closely with the Chicago Housing Authority. Chicago Housing Authority, or CHA, is what's called a sister agency to the city. Their funding comes directly from HUD. We often work together to do affordable housing developments, but they are their own entity with their own board. I wanted to touch on a couple things that the Department of Housing does that is important to know when thinking of fair housing and housing rights. So we are, I'll say a little more about this later, we are in the midst of gearing up for another round of emergency rental assistance. And in the midst of that, we have established a pro bono legal service to work with residents if they are experiencing lockouts from their landlords or evictions that are not allowed under the eviction moratorium. So that we have a pro bono legal service through the Lawyers Committee for Better Housing. It's very important right now. We've seen an uptick in lockouts, which are illegal. And it is now a little tricky to know which evictions are allowed and which are not, because there are differences depending on income and depending on if there was a COVID loss of income and so on. So through the Lawyers Committee for Better Housing, we are able to provide free help to people on that. And I think one of the things I just want to stress is that our programs, our policy work, our underlying goal is to ensure the equitable distribution of affordable housing in Chicago so that people can have choices. And that's really, I think, some of the bottom line of fair housing, right, is that for too long we have had parts of the city that have excluded people who were low income, that have excluded people of color. My belief, our belief in the Department of Housing is simply that if you need a subsidy to live affordably, you should have just as many options for where to live as those who do not need a subsidy. So there's a lot of work to do in Chicago to make that possible. That is our belief. That's our underlying mission and what we're pushing toward. I do want to mention that last year we established a new bureau in the Department of Housing, which is the Bureau of Community Engagement, Racial Equity, and Strategic Initiatives. And that is run by Managing Deputy Cindy Soto. Through that office, we did the first racial equity impact assessment of low-income housing tax credits, one of our biggest, our single biggest source of affordable rental housing. We did an analysis of the impacts by race of our own program. We published those results in March, and we are changing the way that we distribute those resources accordingly. So that's something we're working on as a department. Happy to answer any questions about that. And then I'll end just by saying that later this spring, we are launching a third round of rental assistance grants for renters and property owners who are financially impacted by COVID-19 shutdowns. In our first two rounds, we distributed over $26 million to over 10,000 households in rental assistance. So we're excited to be gearing back up again for this time a much bigger round and able to help more people and to provide a deeper amount of subsidy for people who need it. So those are some examples of the ways that we work. We find the commission to be a very important partner in that work. I'll stop now and see if there are questions later. Thank you.
Well, thank you very much, Commissioner Novara, and thank you for joining us. That's very interesting, very good information. And now moving right along, I'd like to introduce the first speaker, Deputy Commissioner Joanne Newsom.
Hey everyone, good afternoon. I see there are many attendees. I'm trying to share my screen. Thank you for joining us, everyone. I'm trying to share my screen. Okay. So again, I'm Joanne Newsom, Deputy Commissioner here at the Commission on Human Relations, and I'm going to give an overview of the Chicago Fair Housing Ordinance. So the city of Chicago has two anti-discrimination laws. The Chicago Fair Housing Ordinance, which we will focus on today, which prohibits discrimination in housing, and the Chicago Human Rights Ordinance, which prohibits discrimination in employment, public accommodations, which is really like a store or a business that's open to the general public, and credit transactions, like perhaps securing a mortgage. The mission of the Commission on Human Relations is to promote appreciation of the city's diversity and to work to eliminate prejudice and discrimination in Chicago by enforcing those two anti-discrimination laws, monitoring hate crimes and assisting victims of hate crimes, mediating conflicts between groups in community, educating the public as we're doing today, and advising city government. So the Commission on Human Relations investigates and holds hearings on formal written discrimination complaints. A complaint can be filed by any member of the public or by the commission itself. One thing that's important to note is the commission is a neutral body. We do not represent either side. We don't represent the complainant, the person who filed the complaint, or the respondent, the person against whom the complaint has been filed. The Chicago Fair Housing Ordinance covers 14 areas or what we call protected classes against discrimination, and the 14 are listed here. The ordinance also prohibits retaliation, which is when a respondent takes some action against the complainant because they complained about discrimination. For every complaint filed, the commission conducts a full investigation to determine whether there is sufficient evidence of violation of the ordinance. And this occurs unless the parties reach a settlement during the investigation or the complainant decides to voluntarily withdraw the complaint. If the full investigation goes through and at the end we discover that there is sufficient evidence of discrimination, that the ordinance was violated, the case proceeds to a settlement conference that's run by an independent mediator. If at the end of that conference there is no settlement has been reached, the case then proceeds to a public administrative hearing before an independent hearing officer, after which the commission's Board of Commissioners makes the final decision on whether or not there was a violation and whether or not there are penalties that we should enforce. Those penalties may include $1,000 up to $1,000 fine that's payable to the city of Chicago, and remedies for the complainant include financial or monetary awards for out-of-pocket losses, emotional distress, extra penalties, or what we call punitive damages for over-the-top violations. The commission can also order the respondent to make some sort of, do something to correct their discriminatory behavior. The complainant is also a prevailing or winning complainant is also entitled to attorney fees if he or she was represented by an attorney during the hearing. On the other hand, if we find at the end of the hearing that the respondent did not violate the ordinance, he or she is not entitled to recover attorney fees from the complainant. Other penalties that can be awarded, or other penalties can be if a business or a real estate agent or agency has been found to have violated the ordinance, it can affect the business license. It can also affect your ability to engage in city contracts. So this is the beginning of Fair Housing Month. April is Fair Housing Month. We're all here for the same reason. So fair housing increases housing opportunities for everyone. Housing plays a large role in defining a person's quality of life. Where you live, as we all know, affects your access to community amenities such as transportation, employment, and the like. So who can be sued under the Chicago Fair Housing Law? That's anyone, including a corporation, who has the right to sell, rent, or establish rules or policies for any housing within the city of Chicago. In other words, it's anyone who has any sort of control over the housing unit. Under the Fair Housing Ordinance, you cannot file a complaint against your neighbor. You can't name your neighbor as respondent under the law because that person does not have control of your housing. However, if you've complained to your property owner or your property manager about discriminatory behavior from your neighbor and they refuse to address it, you can file a complaint against your property owner or your manager. So these are several acts that are considered to prohibit discrimination under the ordinance. There's failure to sell or rent a housing unit, posting a discriminatory notice or ad, applying different terms and conditions of sale and rental, steering someone to another neighborhood or to another area of the city because they'd be more comfortable, termination of tenancy or ownership rights, harassment, including sexual harassment, and failure to accommodate a disability or religious practice. And you have to claim that one of those things were done because of your membership in one of those 14 classes that we spoke of earlier. So I'm going to switch gears and kind of narrow our focus on source of income discrimination because that is the most commonly filed basis here at the Commission. So source of income under the Fair Housing Ordinance is defined as the lawful manner by which an individual supports him or herself and his or her dependents. Narrowing it even further, a Section 8 housing choice voucher is considered a source of income. We're going to focus on that because that's also under source of income, the most commonly filed basis. So it's a violation of the law to refuse to rent to a person who meets all the qualifications for a unit because that person plans to use a voucher. It's a violation to make any sign, online posting, or ad showing that vouchers will not be accepted. That includes just the blanket statement, no Section 8, but it also includes not set up for Section 8 or not pre-approved for Section 8. Just a side note, there's no such thing as being set up or pre-approved for Section 8. It's a violation to refuse to cooperate with the minor administrative requirements of the voucher program, such as completing routine paperwork or allowing inspection of your property. It's also a violation to charge higher prices or otherwise imply different terms or conditions because a person plans to use a voucher. On the other hand, it is not a violation to apply reasonable tenant selection criteria or rules as long as the property owner or manager does so and equally again applies it across the board to all rental applicants. It is also not a violation to accept another qualified applicant who is ready to rent instead of holding a rental unit for a voucher applicant who is not ready to rent. This often happens. So let's say, take an example. I'm a voucher holder and I go and apply to rent a unit. At that point, the property owner will engage with the Chicago Housing Authority, which administers the voucher program, to the rent negotiation process, allow inspection of the property. There are lots of things that go on, which could take 30 to 60 days. The property owner or manager, even though I've already applied, the property owner or manager is not required to hold that unit through that 30 to 60 day process. So if someone approaches the property owner, applies for the unit, and they are otherwise qualified, the property owner can release the unit to that person. So minimum income requirements under Commission case law, we support the use of reasonable minimum income requirements, the most common of which is that an applicant's income must total at least 3 times the amount of the rent. However, if the applicant is a housing choice voucher holder, the rent used in that calculation must only be that portion of the rent for which the voucher holder is actually responsible. So now switching gears again, we don't get a lot of housing complaints filed by people with disabilities. However, the ordinance requires that if necessary to fully use and enjoy a housing unit, a person with a disability under the ordinance must be allowed to 1, make reasonable changes to the unit or common areas at his or her own expense, and they must be allowed to request reasonable accommodations or modifications to rules or policies or services, regardless of the actual rules. So in other words, if a person wants to bring a support animal, even if there are no pet rules, the property owner must allow the person to have a support animal. That will conclude my presentation. We're going to make these slides available where there's more information. And I'm going to turn it back over to Norman. Thank you very much.
Well, thank you very much, Joanne. That was very good information. And moving right along, our next speaker, our next panelist is Kristen. Kristen, go ahead, Kristen.
Thanks, Norman. Hi, my name's Kristen Lee. I've been an investigator here at the Commission for 16 years, and I'm going to explain how to file a housing discrimination complaint with the Commission. To start the process, please call our intake line. The phone number for the housing intake line is 312-744-5879. I'm going to type that into the chat so that you have it in writing as well. So again, 312-744-5879. For callers with limited English proficiency, we do have Spanish-speaking investigators, and we also have translation services for other languages as well. The purpose of that initial call is to determine if the Commission has jurisdiction over your complaint. In other words, the purpose of that call is to determine if the Commission is the place where you should file. If it's not, we'll refer you to another agency. The Commission will have jurisdiction over your complaint depending on 3 factors. The first is the location of the incident. Did it happen in Chicago? The second factor is the timing of the incident. Did it happen within the 300 days prior to when you file your complaint? And third, finally, the third would be the type of complaint. Did it involve an action in a protected class that's covered by the Chicago Fair Housing Ordinance? And we'll go into detail with you about that during the call. Again, if it turns out that we don't have jurisdiction over your complaint, we will refer you to another agency. So assuming we do have jurisdiction, then we'll schedule an intake appointment with you. That can be done over the phone, and a telephone intake session would take anywhere from about 45 minutes to an hour. And to prepare for your appointment, you'd want to gather certain information in advance of the appointment. Think of the 5 W's: the who, what, where, when, and why of what happened. So for who, we want to know who you want to file the complaint against. We would need their name, address, and phone number. Let's say you don't know who owned the property. Someone who you were texting with named Bob texted you and just said, no, I'm not going to rent to you. But you want to name them as a respondent and you think that they might own the property. If you can provide the address and unit number of the apartment, the Commission will conduct a title search to help you determine who the proper owner is of the property. The second factor, what? Tell us what happened. So for example, did the landlord refuse to rent to you because you have a housing choice voucher? 3, where? Where did the incident happen? Again, we would need the specific address of the property, the subject property. 4, when? The date of the incident. So in a case of refusal to rent, that date would be the date it was communicated to you that you were denied the apartment. Maybe you received an email or a text message where they said you were denied the apartment. Then 5, why? You'll want to explain to us why you believe what happened was because of your protected class. So after the intake session, an investigator will type your complaint and send it to you for your signature. The complaint is considered filed once the Commission receives the complaint in the mail from you. Please keep in mind you have 300 days from the date of the incident to get your complaint filed. So if you prefer to file the complaint yourself, in other words, if you prefer to write it out yourself, there are forms available on the Commission's website, as well as we can also mail those forms to you. I will put the Commission's website into the chat so that you can visit our website. It's a great resource. There's all kinds of information available there. It's www.cityofchicago.gov/human relations. Please do check that out. Did I have any typos there? So I just want to know, as a final note, I just want to mention that there is no cost to file a complaint at the Commission. So please don't let cost, prohibit, get in your way of filing the complaint. If you have any questions, if you just want to talk through your situation, that's what we're here for. So go ahead and give us a call. We're happy to help. Thanks so much.
Thank you very much. And our next speaker is Connie.
Good afternoon. My name is Connie Simonelli. I'm an investigator here at the Commission, and I will review the investigation process. So once a complaint is docketed, meaning it was accepted by the Commission and assigned a case number, the Commission will mail the complainant an acknowledgement of complaint filing packet and mail the respondent a notice of the discrimination complaint filing packet. These mailings contain a copy of the complaint, explain the investigation process, explain the responsibilities of the parties, and provide the due dates for respondent to file and serve the response to the complaint, and for complainant to file a reply to the response. Generally, the respondent is expected to file a response 28 days after the Commission mails the notice of discrimination complaint filing packet. And the complainant is expected to file a reply 28 days after the response was filed and served. The packets also include the forms that the parties should use to prepare their response or reply. These forms are also available on the Commission's website. After the parties' filings are complete, an investigator may request additional information or documentation and conduct interviews. At the investigation stage, parties have the option to resolve the case through settlement, and parties may ask the assigned investigator to facilitate settlement communication, or the parties may negotiate directly. At the conclusion of the investigation, the investigator submits a written summary of the case to the Commission's Executive Compliance Staff, ECS. If ECS determines that there is substantial evidence of discrimination, the parties may be ordered to attend mediation. At this point, unless the parties have agreed to settle, the Commission will prepare to conduct a hearing. If ECS determines that there is no substantial evidence of discrimination, the case will be dismissed. That is the investigation process in a nutshell. Investigator Albert Robinson will present next. Thank you.
Thank you, Connie. Hello, my name is Albert Robinson. I've been an investigator here at the Commission for 24 years. I'm going to tell you what documents you need to submit during an investigation. After a complaint is filed, the complainant, the person or entity, that filed the complaint against submits a response to the complaint. The response to the complaint consists of verified response, which are statements admitting or denying each numbered complaint, a position statement. This is what happens. This is the respondent's detailed explanation or version of what happened, and supporting documents which the respondent believes shows that he or she did not discriminate. Respondent supporting documents often include written policies, relevant application material, written communications such as emails sent between the complainant and respondent, and sometimes comparative data. For example, if a complainant claims that a respondent refused to rent an available unit to her because of her source of income, in other words, she has a housing choice voucher, but the respondent can show he or she rented to several housing choice vouchers at the same property, that information will be submitted as documentation to the Commission. After the response is filed, the complainant files what we call a reply to the response. In other words, rebuttal. In this reply, complainant states whether he or she agrees with or disagrees with allegations that the respondent made against the complainant in their response. In other words, the complainant has an opportunity to say why the respondent response is not true, and hopefully can submit documentation to support that. Additionally, a person or a complainant want to submit supporting documents, which varies depending on the facts of the case. If a respondent refused to rent to you, a complainant might want to submit a copy of the advertisement for the apartment, any written written communication such as text messages, emails, copy of the application, and in case of housing choice voucher, submit a copy of your housing choice voucher. Thank you for your time. Back to you, Norman.
Thank you. Let me just thank our panelists for sharing the information to our viewers on how to identify and file a discrimination claim with the commission. Let me tell you, every time I hear you guys speak, I pick up some new information that's very valuable. Now, what I would like to remind the participants is that all the questions in the chat will be answered at the end. Now, at this time, we'll open up, so keep those questions coming, please. At this time, we will open up to 15 minutes of Q&A to the panelists. But before we begin, please let me once again state the following disclaimer. Today's program is for general informational purposes only and is not intended to constitute legal advice. The Commission on Human Relations is a neutral party on any and all matters before the Commission. Now, viewers should contact their attorney or legal services provider to obtain advice with respect to any particular matter. The use of and access to this webinar does not create an attorney-client relationship between the viewer and the commission. Now, let me ask a question now. Kristen, I have severe allergies to dust and mold. Can I ask my landlord to remove the carpeting in my apartment and replace it with a hardwood floors because of my disability?
Thank you, Norman. Good question. So you can make the request, but the landlord is not required to pay for that. As a person with a disability, you can request to make changes to your apartment or to the common areas of the property if those changes would be necessary to fully use and enjoy your property because of your disability, unless it would create an undue hardship, but it would be at your own expense. Other examples would include adding grab bars to the bathroom or putting in a ramp in a common area for accessibility. Additionally, a person with a disability may request a reasonable accommodations to the rules or to the policies. So for example, requesting support animals or service animals reside at the property. Thanks.
Okay, thank you. Now, Connie, let's say I have a conviction on my record, so I keep getting rejected for housing. Can they do that?
Under the Chicago Fair Housing Ordinance, a person's criminal history is not a protected class. So in Chicago, a housing provider, or under the city's ordinance, a housing provider can legally refuse to rent to an applicant based on criminal history. However, the Cook County Human Rights Ordinance prohibits housing discrimination based on criminal history. So you may be able to file that complaint at the Cook County Commission on Human Rights.
Okay. Now, Albert, to you. If I apply for an apartment with my housing choice voucher, does the landlord have to hold the apartment until the Chicago Housing Authority completes the paperwork?
The short answer, Norman, is no. Although the Chicago Fair Housing Ordinance recognized source of income as a protected class, it is not a violation of the Chicago Fair Housing Ordinance for a housing provider to accept another qualified applicant who's ready to rent the unit instead of holding the unit for the housing choice voucher who is not ready to rent.
Okay, well, thank you. Now back to you, Kristen. My roommate and I are gay. The landlord was cool with it and rented to us. Some of the people in the building, though, have started harassing us, and the landlord says there's nothing he can do about it. Can we file a discrimination complaint against the harassers and against the landlord?
Thank you for the question. So you cannot file against the neighbor. You may only file a complaint against a property owner or a manager. The person you file the complaint against, who we call the respondent, must be someone who has control over your housing. But the Chicago Fair Housing Ordinance does cover sexual orientation. So if you're being harassed by a neighbor based on your sexual orientation, you should report it to the property owner or landlord. If they fail to take any action, if they fail to investigate your complaint, then you should come and file a complaint with our office against the property owner or landlord based on sexual orientation discrimination. Thank you.
That makes sense. Now, Connie, I have a disability. And use a wheelchair. I drive a van that accommodates my wheelchair. The new building I moved into has assigned indoor parking. I've asked the building manager if I can have a space near to the door as accommodation, but he said they're all taken, so I have to park much further away. Can I file a complaint against the building?
So under our case law, a housing provider must accommodate a tenant with a disability. However, a tenant may not always receive the accommodation initially requested. Each case is different and any decision depends on the facts of the specific case. However, generally, we expect to see that the housing provider engaged in an interactive dialogue regarding any accommodation requests.
Okay. Now, Albert, I live in a condo building. I am Jewish, and as a religious observance, I affix a mezuzah to the doorpost leading to my unit. The condo board threatened to fine me if I do. Is this legal?
Well, the Chicago Fair Housing Ordinance specifically addresses fixing of religious symbols on the front door of a residence unit. A property owner or property manager is prohibited from interfering with such religious observation, provided that imposing reasonable rules are necessary to avoid substantial damage to the property or undue hardship to the other unit owners or lessees.
Thank you. Now, we got a few questions from the attendees, and this goes to all the panelists. Whoever wants to answer, feel free. First question, why must the hearings be held in person?
I can answer that. We're working on that now. Of course, 2020 presented a lot of obstacles and challenges for everyone. Typically, in an administrative hearing or even in a trial, a formal trial, administrative hearing is simply an informal trial. In order to assess the credibility of witnesses and parties, the administrative hearing officer or the judge in the case of a court, a trial, has to be able to be in person to assess the credibility. So that's why they have to be in person. We're trying to figure out a way to maybe pivot that a little bit, but for now, they're being held in person. We held them up all of last year, but we're currently scheduling administrative hearings going forward. Thank you.
Well, thank you, Joanne. Like I said, we all know that the world has changed for us. And here's another question. Due to the airborne pandemic, are owners now not allowed to show apartments while they're still occupied?
I'm happy to pitch that to one of the investigators.
So a question that you would pose to our office would be regarding if an incident that you're experiencing in your housing is covered by the Chicago Fair Housing Ordinance. So I don't think that the question would necessarily fits into the services that we provide. If the only thing I could think of is if you had a disability and you requested an accommodation to your property owner because of your disability and it was denied, then you could file a complaint with our office and we would investigate that complaint to determine if there was a violation of the Chicago Fair Housing Ordinance. I hope that helps.
But just to add to that, there is just looking at it generally speaking, there's now no ordinance or law that prohibits a property owner from showing the property. I think it's I think people have decided, property owners and managers have decided that they will do virtual showings as opposed to in-person showings, but there's nothing that prohibits you from doing either one.
Thank you very much. And let me tell you, we have a pretty active group because we keep getting these questions. Here's another one. Can you end your lease early if your neighbor is using substances and you're allergic to the substance, property management was informed.
That might be considered a landlord-tenant dispute as opposed to a discrimination dispute, however, a complaint. However, if you're allergic to whatever substance they're using, and you've told the property owner that you can't live there while they're using those substances, and they refuse to address that situation, I hesitate to say that you can end your lease, because that's all the contract law, that's a whole different area of the law. But I would say you would have a discrimination complaint against your landlord if he or she refused to address that issue.
Now, I have a question for Kristen. I have a family of 5, and I know we can fit in a 2-bedroom apartment, but the manager of the building I want to move into says I have to apply for at least a 3-bedroom apartment. Can he do that?
No, probably not, but it depends on the size of the bedrooms. For each bedroom, the city's occupancy code requires a minimum square footage per person depending on their age. So for each person age 12 and older, there's a required 50 square feet. For each child between the ages of 2 and 12, there's a required minimum of 35 square feet per bedroom, and there's no square footage requirement for babies 2 and under. So let's say that your family of 5 consists of 2 adults and 3 kids ages, let's say 13, 4, and 1. You could rent a 2-bedroom apartment if one of the bedrooms had at least 100 square feet. So picture a 10 by 10 bedroom. And if the other bedroom had at least 85 square feet, picture like a 10 by 8.5 bedroom, or some combination thereof of bedroom sizes that would equal to, in this instance, 185 square feet. So if that happened to you, that's a complaint that you could definitely file at our office, and we would conduct an investigation. When you file the complaint, you would be filing it under parental status discrimination. Parental status discrimination is defined as discrimination against parents of minor children and children with disabilities. Thank you.
Connie, I have a bankruptcy on my credit. So the management company for the apartment building I want to move into said it has to charge me 2 months for the security deposit when they normally just charge 1. Is that legal?
A person's credit history, including whether someone filed for bankruptcy, is not a protected class under the Chicago Fair Housing Ordinance. Therefore, the commission would not have the authority to investigate the complaint. Generally, under our ordinance, a property owner may apply a reasonable tenant selection criteria as long as they do so consistently.
Thank you. And we got some more questions from the audience. Is being, and this goes out to the panelists, whoever wants to take this on, it's fine. Is being a victim of domestic violence a de facto protected class, even though it's not de jure? Because most domestic victims are women, and gender is a protected class. She says, I remember reading that. This is often a winning argument.
You know, we've never had that case brought before us before. Domestic victim of domestic violence or domestic violence victim, that's not one of our protected classes. I know that is under the Illinois Human Rights Act. So you could file that complaint with the Illinois Department of Human Rights. But it is not, that's interesting. That's very interesting because I guess you could say that most victims of domestic violence are women. However, we have not covered that particular area.
That was a great question.
Yeah, that's an awesome question.
I learned a lot from these. Here's another question. The management company where I live allows me to park my van with a lift in the disabled space near the basement door, but they charge me extra. Is that fair? Does anybody know that one?
I'll take that. If this is, I'm assuming if this is a person with a disability and the van is an accessible van? Is that the
I'm
question?
assuming, but
Okay.
I don't know.
If it's a person with a disability who has an accessible van, they park in an accessible space, no, they cannot be charged more money for that. You cannot, that's really that's subjecting someone to different terms and conditions based on their disability. So that would be against the law. That would be something you could file a disability discrimination complaint for.
Here's another question.
Could I just add something really quick?
Oh, yes, please.
I'm sorry. Similarly, if you have a service or support animal, say your building just typically charges more money for pets, for you to have a pet. Many buildings charge what they call a pet fee for cleaning and that sort of thing. If you have a service or support animal, however, that animal is not considered to be a pet. So you would not be subject to the same pet fee as someone who does not have a disability.
Wow, that's a really great point because I wasn't aware of that one. And we have so many people here with service animals. Thanks. Here's another question, which is an interesting one. Can I file with other discrimination departments such as the EEOC at the same time that I file with the commission?
I can take that one if you want. So filing a complaint at the EEOC would be regarding employment discrimination. So we do cover employment discrimination under the Chicago Human Rights Ordinance. Yes, you can file in both places, but if EEOC gives you permission to file in federal court and you go ahead and file that complaint, at that point, we would dismiss, the case here would be dismissed.
Okay, well, we got a great audience, great questions.
And can I just add, you can also file a complaint, Chicago Fair Housing. You can file a housing discrimination complaint here, and you can file it at the Illinois Department of Human Rights, and you can file it at the Cook County Department of Human Rights.
Fantastic. Here's another question. The ability of an owner to rent out and not hold an apartment to another after they filled out a housing choice voucher request for tenancy can cause a person with housing choice voucher to become homeless. So this does not help the person who needs subsidy to stay or get housing. Can this be changed? Did you need me to read that again?
Yes, please.
Okay. The ability of an owner to rent out and not hold an apartment to another after they filled out an housing choice voucher request for tenancy can cause a person, this is a statement, with housing choice voucher to become homeless. So this does not help the person who needs subsidy to stay or get housing. Can this be changed?
I totally understand that. People with housing choice vouchers and other sources of income or subsidies have a hard time finding housing, and we are definitely sympathetic to that. On the other hand, to force a property owner to miss 1 or 2 or sometimes 3 months of rent is considered to be an undue hardship under the Chicago Fair Housing Ordinance. So balancing interests, I totally understand. Now, having said that, even if if the property owner comes to us and says, "Oh, well, somebody else came and I rented to them," they would have to have proof of that. They would have to have proof that they actually rented to someone. It would have to make sense in terms of the timeline. If it was 2 or 3 months later, then we could argue the housing choice voucher holder was going to take the same amount of time. So it's not just a cut and dry. He or she can rent to somebody else. There has to be some evidence to support that. On the other hand, it can be considered an undue hardship to force the property owner to hold the apartment for more than a month.
Wow, these are really great questions. Now, I've got a question for Albert. I'm looking to move into an upstairs apartment in a 2-flat. The owner who lives downstairs is an elderly lady with medical issues. I have 2 children, age 2, and the other just turned 1. The owner said she would rent to me, but because of her age and her disabilities, she can't have young children over her head because they make too much noise. Can she reject me and my family?
Well, Norman, that is considered parental status discrimination. The commission has previously held that a property owner may not refuse to rent to an applicant based on a stereotype or generalization. Refusing to rent to an available, refusing to rent an available apartment to someone who has 2 young kids based on an assumption that they will make too much noise would likely be found as a violation of the Chicago Fair Housing Ordinance. Similarly, a property owner or property manager cannot refuse to rent to someone because he or she has a minor teenage children. In other words, I never rent to someone with teenage boys based on an assumption that teenage boys would cause problems or make more noise.
Great. Here's another question. We got a very active group. I love this. Can a landlord ask you to move just because you filed a complaint against them?
They could ask you, but that's retaliation. So no, the short answer is no, that's considered retaliation. And that's one of those areas, it's not really a protected class by actually technically, but it is an area that's that's prohibited by the Chicago Fair Housing Ordinance. So if you complain about discrimination and then your property owner takes any action against you, raising your rent, serving you with eviction or termination of tenancy papers, anything, that's considered retaliation. And you can definitely file a complaint here at our office.
Okay, wonderful. Well, I got a question for myself real quick, because I've gotten calls where people are renters and the property is going under foreclosure. And sometimes they ask, who do I pay? Do I continue to pay the landlord? Have you guys heard of any situation like that? Or what would somebody do in that situation when the landlord is asking to be paid?
Sorry, can you start from the beginning? Say that again.
I rent in an apartment. It goes on to foreclosure. And the landlord still is telling me to pay rent to him or her. What do I do in a situation like that? Does that make sense?
Yes. You know, I am not, Commissioner Novara, you might have more information about that. Can you expound on that?
Yeah, thank you, Joanne. And I'll want to double check this too, but I know for sure that an option that tenants have when their tenancy is threatened in that way, like it is clear that the property is in foreclosure, is one can make their payment into a separate account, right? So you might set up an account with your bank, let's say, and say, I am calling this my rent account, so that I have proof that for as long as that foreclosure process went on, I was making my payments. I just don't want them to go into a black hole where I don't know if anybody's actually using them on the other side or if it's going to disappear. So I'm setting them aside here, but I can show you proof that each month I paid it. That would be the way to ensure that a tenant is not then held liable at the end of the process for not having paid rent. Because it's a fair concern to say, I don't know if I should be paying this person rent when tomorrow they may not be my landlord anymore. And, you know, so that's one practice that I know for sure is a safe way for the tenant to protect themselves.
Okay, well, thank you. Well, let me tell you, I see that our time is up. And once again, on behalf of the Chicago Commission on Human Relations, we thank you for attending today's program. We hope that we have empowered you to know about your housing rights. The commission is here to assist you. Thank you also to our sister agency, the Department of Housing, and Commissioner Novara for collaborating with us today. Contact information for both the Commission on Human Relations and the Department of Housing is available on your screen. Please join us next week, April 14th. Porque lo vamos a hacer en español. We're going to do it in Spanish para los que no hablan inglés. Y vamos a mandar invitaciones. It's going to be a live language version in Spanish. So be safe. Thank you very much. And don't forget to get vaccinated. It's important. You have a safe week. There you go. Commissioner Novara.
Just this
fantastic.
morning.
Let's get Chicago vaccinated, and thank you very much for everything. Thank you for participating, and everybody be safe. Thank you.
Thank you.